Welcome to Behind the Law with the Ameli Law Group.
Welcome to Behind the Law with Ameli Law Group, Chantelle Ameli and Mark Ameli of Ameli Law Group in Los Angeles. They handle complex personal injury business and contract cases, and they prepare every case like it's going to trial. I'm Lisa Mosby, your host, and today we're talking about business disputes in California and the difficult decisions around when to push forward with litigation and when settlement may make more sense. Welcome, Chantel. Welcome, Mark. Thank you so much for joining me today.
Thank you.
Thank you for being here.
Chantel, I'm going to throw this question to you to start. What are the first signs that a business disagreement is heading toward litigation instead of resolution?
Well, it's funny because it seems like that's kind of where business disputes begin. Everyone's first inclination is, we're going to sue you. You're not acting right. We're going to sue you. So it starts very aggressively like that way. And I think after you actually speak with an attorney who gives you proper advice, that is, typically your attorney will talk you through what the issues are, who you're working with, what the relationships are, and try to figure out, is there a way to actually resolve this matter without having to go to court? And sometimes there is not. So that's the avenue that you choose to take. But um it's always better if you can stay out of court as long as possible so that you can try to get things resolved on your own rather than leaving it up to a jury of 12 potentially who won't care as much about the result as you and your business partner would. Don't you think?
And that's correct. And usually people they have heard about the court, and so see you in court is the first thing that comes out of their mind. But it's the attorney that have to direct them to the right direction, whether it should be in the court system or it should be through resolution, mediation,
Negotiate.
and other forms of settlement. But it's the attorney who will direct them in which way they should go and which way is better for them.
And then can you speak to how the relationship between the parties affect the way that these disputes usually play out?
There's definitely something to be said for two people who know each other in one way or another, whether they're family members or friends or longtime business partners. There's a different sort of expectation there and a sort of a different way that you would handle a case that is perhaps different than like a personal injury matter, for example, that it would be two people that got into a motor vehicle collision who don't even know each other. There's no expectation and there's no feeling bad and there's no guilt about the lawsuit. It's sort of a different thing when you have two people who actually know each other. I know Mark has a lot of cases where that comes into play. The decision of how to move forward depends on that relationship and what it is. um he was just telling me about a case that was just like this yesterday.
Yeah, that's true. We have these types of situations where people have been together for a long time. It's like a marriage, and it's like you are divorcing your wife, your husband, and you're separating the basis of your livelihood in this situation. And a lot of times, this feels that way. Um, People have been friends when they got together. They have been together for an extended period of time, and now they want to split up. So, this relationship is tremendously difficult, and they have to work through that relationship also. And like Chantel said, we have had many cases, but more recently, I had one that the parties have been friends for a long time. They decided to get together, and then something happened that they lost confidence in their relationship. And so I don't want to go deeply into that, but once they lose confidence in their relationship, then the question is, what do we do now? And fortunately, they came to me and I gave them the alternatives that's open to them other than filing a lawsuit in court. And they have selected one of those alternatives and they're proceeding with that. So there are ways to resolve these issues than leaving it to the judge or a jury to decide for you.
Yeah, there's sometimes when it's easier to talk it out. It's better for both parties to talk it out and figure out the situation and figure out the problem. And that doesn't always get to happen because not all attorneys really care that much. A lot of times you'll just go see the attorney. The client will say, I am mad at this guy. He did this. I want to sue him. And the attorneys will say, okay, here's the paperwork. Here's our retainer. Pay us, sign this, and we'll go to court. And that doesn't always give the best result at the end of the day. There are other ways to handle it that may be less costly and also may give a better outcome as far as the relationship itself is concerned. Sometimes you can maintain it, sometimes you cannot.
When we factor in the emotional side of it, sometimes we actually can do more good than just going to law going through the legal process or going to trial is what I'm hearing you say. That leads me to thinking, what tends to happen when businesses wait too long before bringing a trial lawyer into the dispute?
Well, there are definitely good things about trying to work out problems without an attorney. Attorneys sometimes make things more adversary and more contentious and just more difficult to deal with. No one wants to talk to an attorney. Attorneys are scary and loud, and we have a lot to say about everything all the time. This is not always the best way to handle a situation. So there are times when it's better to sit back and give some advice of how the client should go forward and then see how it pans out. Sometimes it works. And like we have for sure had clients that this is the case. They will come to us and we will say, this is what I think you should do. This will probably work a lot better than us jumping in right now. Why don't you go do these couple things that we've mentioned and then let us know what happens? And a lot of the times things get worked out on their own. Not always, but a lot of times they do. And then there are other instances where we have to jump in and help push things along. I know that Mark has some ideas about that too.
Yeah, I'm smiling because that reminded me of a case where there were two partners, and actually they were relatives also. They were two partners who decided that they wanted to split up, and they came to me to do so. And I told them, we can set up a time so that we can get together. And one of them called and said, look, we have this elder in the family. We have decided to go to this elder and have him resolve the case. So they went, and I asked them afterwards what happened. The elder invited them to a restaurant. They came to the restaurant. One sat on one side of the desk table, the other on the other side of the table. And the first question the elder asked, one side jumped up and said, that so and so did this and that. And obviously, the settlement broke down right then and there. So, even though it's good to try and resolve your issues yourselves or with an elder in the family, the problem is that in order to mediate these cases, you have to go to somebody who's aware of the mediation. You can't mediate in a restaurant. You have to have some formal praise. There has to be some agreement signed. There has to be some. So these are things that you have to bring to the party's attention so that they know what they're facing rather than just jumping at each other and ruining the possibility of settlement at that point in time.
Can you share with me what mistakes businesses make during negotiations that end up weakening their leverage later?
Well, each business has some leverage. Sometimes they want to hide the leverage they have so that they can save it for the time of trial. Sometimes the leverage that they believe they have, in fact, is false. They don't have a leverage. They believe they have a leverage. Um, and you have to delve into these issues to find out what is a real leverage, what is not. And then you go through the process of litigation. When you go through litigation, there is discovery. So the other side can discover things, including the leverage that you believe you have. And all of a sudden, you've realized that that leverage doesn't exist any longer. And so, how do you proceed now? Now your condition is weaker, right?
Well, I think a big part of it too is leverage depends on whether you know the law. Because you may, just like you were saying, you may think you have leverage, but in fact, that's just a fact that doesn't really affect anything one way or another. If you don't know what the law is, if you don't know what position you're actually in, you may not really have as much leverage as you think you have, and that becomes troublesome down the line. So when you're coming in with this bravado of I know this and I have this, if you decide to go through litigation, like you were saying, it's all going to come out anyways. It's just kind of a matter of when are you going to show your cards? Are you going to hide them? Are you going to show them? And what is the purpose of hiding them? And what is the purpose of showing them? It all comes down to what does the law say? And are you on the right side of it or not?
And I would guess, the biggest mistake might be not knowing the law, but there's probably times when these cases trace back to poorly written agreements, agreements that were rushed, unclear, or never fully documented. I would assume those would be big mistakes. Do you want to speak to that a little bit?
I think that we both would agree that that is always the case. Something is wrong, and that's when things get messed up. If people would just come and make that initial investment with their attorney first, put together an agreement that actually has everyone's ideas in it, and it is created according to the law and it requires all of the things that are required according to the law, then things will move along generally a lot easier. But um, even in those cases, even if you have a great contract, there will still be times when people just don't agree anymore as to what the terms are. So it kind of goes back and forth either way. I mean, we've had to deal with so many contracts that even we have written that someone else is arguing about it. So, I mean, it can happen at any time.
Yeah, the question there is that businesses are growing, they're changing, um, markets change, and all of those affect what's happening as far as the contract is concerned. So, if there's a lease agreement, as an example, and you have a 10-year lease agreement and you agree to an increase of 5% per year. Now, in the fifth year, you hit a market where 5% per year doesn't make sense any longer. The market is now growing at 2% per year. So you're stuck with that 5% per year, but the market is going at 2% per year. So there are changing situations, and these changing situations will cause disagreements as far as the contract is concerned, renegotiations as far as the contracts are concerned. And we've seen that all the time.
That makes sense, Mark. You know, in California business litigation, what usually changes once a case enters discovery and both sides start seeing the actual evidence?
I think both sides become a little bit more humble, honestly, because everyone comes into litigation thinking they're gonna win. I don't think anybody goes into litigation thinking I have no case. Even defendants come in saying the plaintiff has no case, we're gonna win, and this is just the mindset. And that's not always the way it ends up. Obviously, one side is going to win, but having the information come out a little bit at a time, we start finding out, oh, this was a little bit toward the plaintiff. Oh, nope, this is more toward the defendant. As that information comes out, you see who is following the law more and who is actually getting that leverage to actually be the winner of that litigation.
We had this case that a client came to us um, about about a month or so, 2 months before trial, and his attorney had told him that he can't go to trial, bringing excuses as to why he cannot go to trial. So he came to us, and we accepted the case because he had nowhere to go, and we basically started uh, looking at the case, started looking at the defense and see what the defense has been talking about in this situation. And we realized that the former attorney had actually filed the case too late, and he had a chance to fix it, but he did not fix the problem at the time when he could have fixed it. And as a result, where this case was, it was a couple of $1 million business case, whereas he could have gone to trial and actually won that case because of that technicality that the former attorney had missed. Uh, the case could not go to trial and the case had to be dismissed. So things like that do happen, and that's what you find out during the litigation. And that's what the former attorney had found out. And the reason why he didn't want to pursue it was because he had made a mistake. And rather than telling the client, look, I made a mistake and this is my insurance, go ahead and sue my insurance for my mistake, he substituted out of the case. And
And left him on his
we,
own.
yeah, so that's what happens in litigation.
So, where I'd like to wrap this up today is one final question, Chantel. This one's for you. What usually tells you a settlement is being driven by strategy versus fear, exhaustion, or financial pressure?
Oh, well, I think fear, exhaustion, and financial pressure are always going to be present, even if there is the luxury of having a strategy. Strategy is always necessary, right? You sort of have to have your game plan jumping in. You need to know what the litigation is about. You need to know what the rules are. You need to know what the defenses are, depending on which side you're on. You have to figure out what your game plan is with your client. How far are you willing to go? Are you willing to go to trial or do you not want to go to trial? Um, those are things that are just sort of inherent in litigation. But regardless, even prior to getting to litigation, all of that fear, all of that exhaustion, it's going to be there already and it's only going to get worse. So the stress just kind of doubles as we move along and sometimes triples when you have to actually go to a trial. That's very difficult for clients to do. Like for me and Mark, we like that. That's showtime for us. We go to trial and we're happy to be there. For the clients, it's not really the same situation. And I know a lot of our clients would prefer to just get it done if we can without doing that actual trial. But sometimes we have to do it, and that's the fun part for us. We just try to bank our clients' stress and see if we can get them to stay calm and remember what they're here for and really just breathe through the tremendous troubles of going through a trial. Um, yeah.
I wouldn't go as far as fun, but it is something that we do on a daily basis. So we are used to being in those circumstances, the pressure circumstances, the exhaustion circumstances. Every trial, for every day of trial, you have to prepare about 3 days of work. So when you have a 10-day trial, you have prepared for those 10 days a good month in order to be ready for it. So we are used to working under pressure and that, but our clients are not, and it's very very stressful for them to be in those circumstances, and in some situations it's a matter of I shouldn't say life and death, but it's a very serious circumstance for them. So we do consult with our clients ahead of time. We do go through the process with them. We do explain that there will be exhaustion, there will be tiredness, but we have to go through the process together, and we do.
And financial pressure comes from so many different angles. It can come from the case itself, it can come from paying attorney's fees, it can come from paying court fees, expert fees, which are exorbitant. So we always try to talk through all of that so that we can figure out where is our position and what in fact is going to be our game plan moving forward.
Mark, Chantelle, I want to thank you both for your insights today. This has been an enlightening conversation. Thank you.
Thank you so much.
That wraps up today's episode of Behind the Law with the Ameli Law Group with Chantelle and Mark Ameli. If you're dealing with a serious legal issue and want a team that prepares every case with a trial mindset, you can learn more at amelygroup.com. And if you found this episode helpful, be sure to subscribe, leave a review, and share the show with someone who could use it today. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.